The following content reflects the personal opinions and perspectives of the hosts. These views do not necessarily represent those of their employers.
Good afternoon and welcome to the Blue Sky Business Acquisitions Podcast. Today's topic is legal review in the M&A market, and we are blessed to have our co-host, Jan Pierce. Jan, we'll get to you here in a second. Our podcast today is brought to you by Strategic Wealth Partners, a top-tiered financial planning firm whose goal and objective is to provide you with successful wealth strategies, independent advice, and the personalized service that you as buyers and sellers deserve. Ruben and Joe, your sponsorship means so much to us guys, and to all the listeners out there. These guys are absolutely amazing in the wealth planning market. So, without further ado, our spectacular guest, Jan Pierce, who is an M&A lawyer here in Wisconsin, is joining us. Jan, if you'd like to share a little bit with our listeners, kind of who you are, what you stand for, and maybe a little bit about what your mantra is.
So I've been practicing for a little over 25 years. I spent the first half of my career in a couple of mid-sized downtown Milwaukee business and real estate firms. Also did a couple of years doing bankruptcy work, which was a nice experience to have. And then in 2012, so about 13 years now, I've been on my own, and I focused my practice solely on working with entrepreneurs, closely held companies, and then now for the last 5 or 6 years, doing a lot more M&A type work. So I've limited to my practice to what we call business and real estate transactional, which in lawyer speak means I'm not doing any litigation. So I don't bother going to court anymore. I let other lawyers do that. And I spend my time working with entrepreneurs and folks who are buying and selling their businesses and buying and selling real estate. So, and I guess if I had a mantra, I wasn't ready for that one, but I'm always proud of saying that I'm a practical lawyer. And by what I mean by that is I'm on my own. I'm no longer in a much larger firm, and frankly, my clients tend to be a little bit smaller. It doesn't mean they're small, but they're not the kind of clients that are usually hiring multi-hundred lawyer law firms. So I try to keep my work very efficient, use the skills and principles that I learned in larger firms, but really tailor them to the transaction and make sure I don't over lawyer them. So.
Wonderful. Well, thanks so much for sharing, Jan. And we've worked together in a variety of different capacities. Either you're representing a seller or you're representing a buyer over the last several years. And yeah, a practical approach to legal is always a beneficial thing. So I appreciate that. Our agenda today covers a lot of legal topics associated with M&A. And I think I want to just jump right in and talk about the difference between an LOI and an offer to purchase. As myself and Tom are business brokers, we see both of these. And I'm just curious, as a practicing M&A attorney, which one do you prefer and why? And, which one would you say opens up the most risk for the transaction?
So just to put a little more flesh on it, by LOI, we're talking about a letter of intent, which is just a written
Correct.
document that sketches out the terms of a deal. And most of the time, if it's done properly, it's non-binding. It means that it's the parties sitting down. What I like to say is it's the terms that two business people would be scratching on the back of a napkin if they were sitting in a diner talking about the deal, right? They're not going to get into 6 or 7 pages of deal points. They're concerned with the purchase price, whether there's going to be any seller financing, when it's going to close, are there any contingencies, how much time they might have to stay on after the transaction to work with the buyer, really big picture points. And I think there's a real benefit to using an LOI. It allows the parties to very quickly, I describe it as like a first date kind of thing, like going to a coffee and sitting down and figuring out if there's any chemistry there. Like, let's not waste a lot of time. You and I figure out if we've got something worth doing. The offer to purchase, and I think more strictly defined as the state broker form that folks like you guys are using, it's a great form. It's designed to be a complete purchase agreement. Now, sometimes us lawyers like to do bigger, longer, customized agreements. It does allow us to add a lot and to be a lot more custom and tailor it to the transaction. And I think most of the time we end up adding, doing an asset purchase or a stock purchase agreement. But the offer to purchase form provides a really great way to, frankly, to memorialize an entire transaction, and you can use it as a purchase agreement, and we've done that. What I see as a potential problem of using the offer to purchase is when it's used as an LOI, but it's as binding as a purchase agreement. And I think I've talked to you before about this, where I'll point out, like, why didn't we deal with this in the offer? And you'll say, well, this is basically more of a letter of intent. So the problems arise when the parties use the offer to purchase for something other than it was intended to. You know what I mean? Like maybe you meant to use it as an LOI, which was to kind of mark up the deal points, but all of a sudden it's a binding agreement. So they talk with their lawyer later, and everybody realizes they forgot something. They want to talk about it. They say, no, we've already got it in the offer to purchase. So I just think that as long as the parties use the offer to purchase for what the parties want to use it for, it's great. And for instance, if you're using it as an LOI, like from a broker's point of view, I think it has a really nice structure to it. You get to fill in some blanks, add some extra stuff. If you're planning on using it as an LOI, I think you just make sure you add that this is non-binding, and the goal is to see if we're on the same page and do a purchase agreement later. However, if you are planning on nailing the parties down to the and finalizing a deal, that you make sure to take a deep breath, circulate it, get it reviewed, so that when everybody signs off on it, they realize it's not a first date anymore. We're getting married, so make sure it's right. So I'm fine with using both documents. It's just using them properly. So, and I guess
Perfect.
one more piece here is I think that as lawyers are probably a little more comfortable using the LOI. We can scratch it up on a Word document, pass it around, and but I think the brokers tend to be a little more comfortable with the offer to purchase. So both work for me.
Well, Jan,
Yeah.
I appreciate you being on today. It's definitely a pleasure to chat with you. I think what you're saying resonates so much with both Matt and I, as far as how we deal with the offer to purchase or LOI. When it comes to negotiating, right? You don't want to necessarily over negotiate, right up front when you're still kind of in that dating period.
Right.
And the offer to purchase really has a lot more structure to it that provides less wiggle room, once you sign the dotted line. So the LOI makes a lot of sense in some cases and otherwise not. Certainly working with an attorney like yourself is helpful if we have the LOI, because you understand that we need to hash out some of those deal points, and that takes time. As far as the LOI goes, are there specific things that you're always looking for, maybe outside of price and terms, or maybe in price and terms? What kind of defines a really solid LOI to you?
So first of all, let me tell you where I can see a LOI kind of goes off the rails. And I bring this from my larger firm experience when I've worked with clients or other attorneys who've been working with clients, and they're working on an LOI for months. And sometimes the more cynical me says, something tells me that the lawyers are doing this just to bump up their billing hours. You know, they can work on the LOI for 3 months and then they can spend another 3 months on the purchase agreement. So my philosophy, as I said earlier, is to use a LOI as a very quick, check. Are we on the same page? So yeah, things like purchase price are super important. Financing, trying to get the time frame that the transaction is going to close, and then other contingencies as well. I mean, those are the other big important pieces. I think from if I'm representing a buyer, I want the seller to understand. Look, we'll get married, but we got to make sure that we've answered the question about kids or something like that, right? The buyer wants to make sure that they're going to be able to enter into the transaction subject to a financing contingency. Like everything's fine, but I don't want to be on the hook if I can't get financing. Same is true for a lease. A lot of times in a business purchase, where the real estate isn't being purchased, that business sits in a piece of leased real estate. And so the buyer wants to make sure that after he buys that business, he's got a place to operate that business. So he's going to say, look, that lease deal is going to be with some other party that's not a party of this transaction. So I'm going to enter into this deal that we've hashed out here, but I want to have a lease contingency in here that says I'm going to make sure that I get the lease I want that's satisfactory to me. And then finally, I think probably the most important thing, and I tend to use a global due diligence contingency. And that basically means I get a chance to look at your financials, your tax returns, and maybe other aspects of the business and make sure that the business is right for me. That's a way of saying, hey, it looks good. You're cute. You know, you got a great personality. I think we're going to, it's going to be great going to prom with you. But, I want to make sure I see your credit score. I want to see, your CCAP, make sure everything as it appears is actually true. It looks like a great business, but let's make sure it's not losing money. So just financing contingency, lease contingency, and a due diligence contingency, I think, are the other big pieces.
So, one of the things I see on the bank side of it, right, is when I look at an LOI and it basically outlines the purchase price and leaves everything else very vague, right? So it's very hard for us as the lender to be able to kind of really put the deal in the perspective of underwriting, right? So what are some of the things that I see that are a lot of times missing in the LOI? And this goes back to when I used to see early in my career how deals would blow up, right? And one of them was working capital. Like, it doesn't have to be perfect, right? But it at least has to give kind of the play from the quarterback of how the working capital is going to play out in the deals, and where that comes in, right, is when you're trying to decide if you're financing the working capital or not, or the buyer's bringing working capital in, how the transition period is going to work, right? Like, so if you have, like, let's say you have not defined in the LOI, but the seller believes like, oh, they're going to get for their 1 year of consulting, I don't know, $150,000 of a payment, right, as payment for their consulting, right? And that it doesn't really define where it is. Is it in the purchase price? Is it in a 1099 wage that gets paid, right? And how does that factor into the cash flow of the overall deal, right? Lease, like, knowing that you're going to see the lease and how that works, right? Because leases can sometimes kill deals, right?
Right.
Or
Yeah.
because they're looking to take
Landlords.
their pound of flesh, right, Jan? Like with a new person taking on the lease, right? If they can renegotiate, right, they want a pound of flesh before they agree to sign on. So those are just some of the things, like whether it's an asset or stock purchase, right?
Right.
I don't want to get too far into the weeds, right? Because we could really get in the weeds, right? But like you said, Jan, earlier, a broad framework, where it's a little more than a back of a napkin, right? Where it just kind of, I don't know, I'd say the 7 key bullet points like seller financing, transition, non-compete, right, and working capital, and a few other things.
So I'm glad you brought that stuff up. First of all, I probably never address working capital properly. So I think that's a good point, and it's probably a failure on my part. However, I do always address the non-compete and the transition period and whether it's an asset or stock purchase. I just kind of glossed over those, but you're right, very important. The transition training period and compensation, super important because, well, not only because the buyer is going to have to pay that as far as money goes, but sellers, at least in my experience, they're usually ready to move on. Do you know what I mean? So it's an important part to hash out up front. How long are they willing to stay on and help transition the business, and how much is it going to cost the buyer? So you're absolutely right. That's a super important piece that goes in there. So
one other thing too, and this is Matt's favorite, right, is the timeline for the deal, right? Like
Yeah.
when does the due diligence complete, right? And when is the closing date, like technically set, right? Because, you know, if you have an LOI that kind of spells that out and you give it to your lender and the lender looks at it and says, I don't know if that timeline is going to be doable. What can we do to make an amendment, right, to an adjustment, because it's probably not going to be doable. And I know in conversations with Matt that like when those timelines get missed, you know, when it's clearly in the language of the agreement, right, that's a big deal, because it does put the buyer in jeopardy, right, on their, maybe not on a non-binding LOI, but as you get later into the deal, like there could be real consequences for them not hitting their close date.
yeah, you know, there was one other thing I wanted to jump off of that you brought up too, which is like looking at financing and approving it based on an LOI. That's probably another way I look at these differently. Part of my philosophy on LOIs is that we do it quickly, and then we get a purchase agreement, and then we call the banker in, right? But you're right. Sometimes, you know, sometimes brokers and bankers, they just don't think that us attorneys are all that valuable. They're going to get the deal done. They're going to
I don't know about that, Jan.
and then they're going to call in the lawyers at the end just to paper it up. We're just sort of like this necessary evil. And so what I would hope is that, you know, and all kidding aside, I think it works better when the professionals are talking to each other earlier rather than later. Do you know what I mean? I found that makes a huge difference. And I would agree that trying to finance a deal off an LOI would be tough, even if it's a good one. My philosophy would let's get an actual purchase agreement together, and that the LOI is simply a means to an end. It's like, let's do this quick to see if it's worth papering up, and then get that purchase agreement done and get it over to the banker ASAP for the financing, and then we've got some meat on the bones.
So Jan, what you're really saying is you want to be the leadoff hitter versus the cleanup hitter, right?
Yeah, it makes, I mean, I realize we all have our places, but it does make it a lot easier to deal with some of these things ahead of time. Making sure that wasn't my dog in the background.
Ben's dog is going nuts. There's someone at the door, isn't there? Love it.
One of the things that's been nice about working with like Sunbelt, you know, Matt and Tom for a while is each deal is sort of we kind of learn something from each other, and I think that it's every time we do something together, I think I'd like to say it improves. You know what I mean? And sometimes we'll make comments back and forth. Hey, maybe if you're doing this next time, you should check this box, do this, use this sentence. And I think the deals basically get easier all the time. And so having professionals who have good working relationship just helps, period. It's this is not the kind of work where you just throw it over the wall and somebody else works on it. To some extent, we're all working collaboratively together to pull this together all the way through the deal. So.
Right. And I mean, Ben, a lot of times, as of late, at least, the banks are coming to us saying, hey, we need a draft APA before they're issuing a commitment letter. So, in a lot of cases, I think, we get the LOI and it's that nice shell, but we have to have a deeper dive for the underwriter to approve. What's your viewpoints on that? Because it's not a signed APA, but it is a draft APA.
So I've never needed a draft. They're nice, right? But to have, but as long as you've got a well ironed out stronger LOI, or as Jan put it, a draft offer to purchase, we haven't had that as a requirement to get in a commitment letter. Right now in closing, we've asked to get the final draft of the purchase agreement, right? Because that really defines the final transaction, right? And kind of outlines the bill of sale. And I'll let Jan go into the broader things that are in a purchase agreement. But for us, the final draft comes in more in the closing period than it is in the underwriting stage. So I have not seen that as a requirement to issue a commitment letter, that you have the final draft purchase agreement.
Well, I can tell you that it's on lists, so we'll just leave it at that. That's Jan, you brought something up earlier that we oftentimes, I specialize in daycares, and daycares are a heavily licensed, entity. So we almost always are going to default to a stock purchase agreement versus that asset purchase agreement. And buyers out there, even sellers out there, want to know, well, what is the real difference, right? Because there are differences, but they really do follow the same path.
Yeah, I mean they're actually radically different. Okay, from the outside observer, a lot of times there is no difference, right? The buyer looks just like the seller, and so there's no difference. The difference is in the legal structure, what's actually happening in the transaction. An asset purchase, and I'm just going to guess, I don't have any firm numbers here, but I bet 95% of all transactions are asset purchases. Certainly the majority of them are asset purchases. And in an asset purchase, what the buyer sets up his own corporation or LLC, and then buys all the assets of the seller. So they buy the toasters, the dump trucks, they buy the actual equipment, the furniture. They also buy what we call goodwill. Goodwill is basically brand or company reputation. It's the expectation that you're going to continue to make money, right? If I buy a company and take on, that company has been successful and has a customer base or a client base that's continuing to give money. So goodwill is an asset. The name is actually a form of goodwill. So an asset purchase can be structured so that you buy everything that's in the company that other company has, including its name, trademarks, everything. But it's a brand new company. And the benefit, the reasons lawyers love it is it's very lawyers tend to be risk averse. And if you do an asset purchase, you've got a squeaky clean, fresh new company. Okay. It has no dirty laundry, as I like to say it. Okay. You're just buying the equipment, you're just buying the stuff, the goodwill, and there's no lawsuits attached to that. There's no liability to the extent that a prior company owned a bunch of taxes or had some slip and falls that some personal injury lawyer hasn't discovered yet, or there's some employee lawsuits, a lot of stuff that could, litigation's a big thing. You don't have that when you do an asset purchase. You start fresh and clean. You get everything you want and nothing you don't want. A stock purchase, on the other hand, let me back up one. With an asset purchase, you have to be very careful that you list everything, right? Either with your general descriptions or an exhaustive list. If you wanted all 13 desks, you've got to list all the desks or all the furniture. In a stock purchase, you just buy the company stock or the LLC membership interest. And by buying the stock, by buying the actual company, you automatically own everything that the company owns. So you could buy Acme Corporation, and along with Acme Corporation comes all the dump trucks, all the furniture. More importantly, and to your point, so do come all the contracts. This is and licenses. So the specific reason why buyers will do a stock purchase usually is because they want to purchase or acquire that entity with all of its ongoing contracts and licenses that are in place. Very often, like if you're doing an asset purchase, the buyer has to start from scratch. He has to reach out to all those customers, say, look, we've got a new company, we're new owners, got to start everything else new. In a stock purchase, you just basically jump in, and you even have the same federal tax number, you have the same sales tax number. This is more common in what I would call regulated industries, okay? Transportation companies, motor carrier companies, trucking companies. They have all sorts of insurance and stuff that's all tied in with these EINs, and to start and a whole history of these contracts and ratings that have been established, and starting that from scratch is very, very difficult. Same thing is true with certain medical companies that have all sorts of insurance and provider contracts in place. Starting from scratch is a real pain in the butt. Daycare centers, as you mentioned, have state licensing, and the buyers just simply want to be able to start. When they buy the business, they want to be able to start the very next day and continue operating the same way. And if they didn't do a stock purchase, they'd have to start all over and actually acquire these licenses, acquire some of these ratings, and that could take not just weeks but months. So you lose a lot of time. The other time I've seen this done on a more local basis is for bars and restaurants. Sometimes bars or restaurants will be bought via a stock purchase or an LLC purchase, because the buyer can take over the existing liquor license and continue to serve, and that's the lifeblood of the restaurant, is the ability to continue to sell beer and liquor. There's a little bit of a catch. The owner, there's a change of agent on a liquor license. So the new owner of the corporation still has to go before the local licensing committee and make sure they're not a criminal and they're of good moral character. But there's no interruption in the license. If they did it with an asset purchase, they basically have to close up the restaurant and wait for 2.5, 3 months until they got licensed again. So it's a matter of being efficient. So the super simple answer there is basically always do an asset purchase unless there's a very specific reason to do a stock purchase, which is licenses, insurance, and other regulated issues. And that's just because there's a higher risk with stock purchases. You have to make sure that they don't have any, or you try to make sure they don't have any lawsuits or litigation or tax liabilities out there. But some of that stuff, it takes a while to discover. So,
Jan, are you looking to define if you're going to have the stock purchase agreement within the LOI up front? Or would that change your LOI if you know that it's a business that, will likely be a stock purchase, and how so?
So to the extent that it's going to be a stock purchase or asset purchase, I think you get that up front right away. Okay.
Yeah.
And just everybody's better off knowing, how we're going to get to the prom, right? It's like it puts everybody on notice how we're going to be working forward, what kind of agreements we're going to need, and the issues that are going to come up in the transaction. There are times, and I can think of them, a couple of times recently, where the parties planned on doing an asset purchase because it looked like just a boring, normal asset purchase, but then something came up where the buyer realized that there was a particular license or a contract that was contingent on staying with that entity. And so that changed. It's usually during the due diligence period. The parties are exchanging information back and forth on one deal recently. They found a huge contract that had as a majority of the company's business was all tied to a contract that they would have to assume, and we switched gears. But to the extent get it out there right up in front.
So as far as that goes, within the stock purchase agreement, how are you protecting, whether you're working with the buyer or the seller, your client, post close, right? If things, go sideways, for instance, right?
So I'll tell you up front that the goal is to have things not go sideways. It's obviously, and I have been lucky enough. I've had little things go sideways, misunderstandings, people get their nose out of joint, stuff turns up that's not. I think all buyers discover stuff that they didn't think was as it was, but it's minor stuff. But what I would call big deal stuff would be like unknown tax liabilities or large environmental or employee or slip and fall type litigation items that are, multi-$100,000, $500,000, $1 million claims that are going to can basically put a company out of business. I have never had that happen, but there's two ways we sort of address it. One is in a preventive sort of way. The due diligence that's provided for is got to be a little bit more serious. Instead of just looking at the financials and making sure the company makes good money, the buyer really has to push to get as much information about that company's track history as possible. And this is different in each industry, but you really got to try to dig under the surface in any way possible to find out if there's any litigation, if they're in a particular type of industry where certain types of claims might come up. I'm just going to use an easy example, right? If someone, if Ben wants to sell me his dry cleaners, right? That's just like big red flashing lights go all over. You're really going to be looking for past environmental, toxic discharges, chemical discharges. You're going to look for
property's clean as a whistle, Jan.
Yeah, it's fine. It's that's the kind of stuff that nightmares are made of. I think environmental litigation is probably some of the worst, and that comes with real estate as well. But tax stuff can be hard to find. So that's where having a little bit of a deeper dive in the tax returns is probably helpful to make sure things are filed on a timely basis and that there's no outstanding stuff. And then in the agreements, I think both in the asset purchase or stock purchase, we have what we call indemnification provisions. So the parties agree to indemnify or to basically step up and defend each other or take care of damages, hold harmless for damages related to the other party. A typical agreement would be that the seller is going to agree to step up and pay for or defend claims that happened prior to closing that the new buyer is on the hook for. If for some reason the new buyer is getting sued for something the prior owner did, the agreements are going to state that the prior owner has to step up and defend and make that person whole. We do that in the agreements, but again, you really don't want to get to that stage. The point, if the parties are actually at a point where they're suing each other or their insurance companies are suing, it's a mess. Nobody wants to be there. So we try to get through all those issues prior to closing, hopefully.
Jan, now when you're working with a client, one of the things that we see come up, and UCCs or searches are usually done towards more closer to the closing. But do you ever have UCC searches done so like you can potentially uncover any of those things that may pop up on a deal that could cause delays or could be showstoppers, right? Because that's a lot of times where you flush out those things that you just talked about.
Yeah, so depending on the deal, depending on we all try to use our intuition or best judgment. Sometimes I look at a business that my sense is there aren't really any issues, and I know the banks required a UCC report. We're going to get that 6 weeks out from closing, and that's kind of an extra level of a double check. There are definite times though, and I'm trying to think of an example, but basically if there are reasons to believe that the company may have a number of different creditors out there, right? And there are a bunch of types of businesses that have all kinds of regular, ordinary course creditors they use. Instead of just like one bank, there might be all sorts of vendors that end up taking security interests in stuff. And I think that's really important then sometimes to go back, and I can do these really quickly on our state website. You can search under different names and get a sense if there are security interests out there. So yeah, it just depends on the situation. So, and I actually got hired last year by a client that was, they had a bunch of convenience stores all over, and they were selling them or refinancing them. And basically there were different generations of the family that owned different stores, and they were under different entity names, and they had different vendors and creditors. And this had gone on for decades. And basically they waited until a few weeks before closing to start digging a little deeper. And then all of a sudden it was just like this giant mess of UCC problems that showed up all over the place. I spent weeks. My sole job was to track down, trace, and really sort of put these to tie these particular UCCs with particular lenders and reach out to lenders and get those payoffs. If it can be a real nightmare very quickly if there are a ton of creditors out there that you otherwise didn't know of. So I guess what I want to say is there's no easy answer to knowing when and how to do those, but sometimes the nature of the deal is such that you can anticipate that there's more and different creditors out there, and that's when you want to do those earlier.
Well, thank you so much, Jan, for sharing. UCC for my 20-year career has always been a vein, trying to identify those line items 2 weeks before closing. So, I want to kind of switch gears here and maybe stay in the same place. We're talking about what can go wrong at post-closing. Let's talk about what can go right. And, with that comes a transition agreement. So, when you own a company for 30 years and a buyer comes in and, there's personal relationship, there's employees, there's work in process, there's a whole bunch of things that are going to go into the 30, 60, 90 days after closing, potentially as far out as a year. What's your viewpoint on, the transition agreements? How clearly defined should they be? Can they be broad stroke? I guess kind of fill in the blanks there.
So first of all, they're absolutely critical. I think every single transaction, the buyer is taking over a business. They don't know. They don't know how to operate the computers. They don't know where the phone numbers are kept. They don't the custom and practice of what's going on. They absolutely need someone to show them around the office, walk them through some customer relationships, train them how to do different aspects of the business. So on every single deal, the buyer is absolutely concerned. They don't need a lawyer to tell them this. They know that they need that seller there to kind of help them out for a while. And the main thing is you want to see how long that needs to be. So the term, some businesses are pretty simple. You might need a couple of weeks of sort of full time on site help, then following with a couple of weeks of occasional work, and then maybe a few months of just phone calls and emails. Some businesses are much more intensive. Like I've got something going now where they want to keep the seller on as a salaried consultant or not salary, but a paid consultant for close to a year to work as an integral part of the business in a sales capacity or something like that. But either way, it's critical for the buyer and seller to both be on the same page on that. A happy, successful deal is when I think the expectations of the parties align up with, what they get is what they expected. Okay. And you talk about stuff going sideways, Tom. This is something that sometimes I think we expect the parties to play nicely afterwards just because that's what they should do. But the truth is, sellers are thinking about checking out to the Bahamas, right? They're just like, as soon as they can leave town and get that check in the bank, they want to go do what's the rest of their life. And so it's important that the parties really talk about this, and like as Ben said, as early as the LOI. Say, look, I'm going to need you to stay on for a month or 3 months, or what do you think about a long-term contract for a little over 11 months? And then, of course, both parties want to know, is there going to be compensation involved? And how are we going to pay? How often are they going to? And that's tied to how often they're going to have to be there. Ironing that stuff out, super important. I don't think you have to have, these agreements don't have to be long. I think most of the terms could fit on one page. But I will admit, I have at times learned the hard way that I should have probably been a little bit more detailed in these. You got to make sure that the parties are on exactly the same page post-closing, because the buyer really needs the seller, and the seller, needs to understand their responsibilities. Sometimes there's no compensation involved at all, right? There's as part of the purchase price, the seller agrees to stick around for a couple of weeks and do some work. But very often, if there's like a number of months involved, there's at least some ongoing compensation. So it's fair, it's reasonable, but the parties still need to agree to it. So, super important, though. Super important.
Absolutely. Buy side and sell side, in a lot of capacity, I think one of the things buyers, Tom, I think you'll probably agree with me, buyers are coming in saying, okay, I'm going to pay you this $1 million for your company, and, you're going to stay local. Who's to say you don't start competing with me in 3 years when you get bored? So, from a legal perspective, we're always talking about non-competes and what's reasonable as far as time and mileage. But what, from a lawyer's perspective, the non-compete, right? What's your view on it? What's acceptable? What's not?
So, first of all, I think it's important to differentiate non-competes that are bargained for and agreed to as part of the sale of a business, and non-competes that I think most people think about, which are employment related, okay? Where if you go to, and I think that are typically overused and overbroad. If you go to work for an employer, they make you sign a non-compete that says you won't do the same kind of work for a number of years. And most people, if they've paid any attention to the news, they either think that those types of agreements are unenforceable, or that they're hard to enforce, or they think that they're now outlawed. And the truth is, all of those are sort of true. Those types of agreements are generally disfavored under the law. There's the Federal Trade Commission had tried to outlaw employment-related non-competes. They have to be, when they are legal, they have to be designed in a very specific way to be enforceable. That's completely different than a business agreement, okay? When buyers and sellers agree to sell or purchase a business, that is a solid, enforceable agreement, and courts look at the parties as sophisticated parties who had legal counsel and who bargained these, and it's a necessary part of the transaction. Okay, it's not like you're working for a sub delivery place, and your employer says that you can't be a sub delivery guy anymore in Wisconsin or something like that. What this agreement is saying, look, I'm spending $1 million or $3 million or $5 million to buy this business. And the expectation is that I'm going to have the right to operate that successfully. And so part and parcel of that means you're not going to set up shop next door and start competing with me. Okay. I mean, that would just simply, that would just be a disaster. And because the seller has all these prior relationships and could simply call up the existing customers and move them over to. So these are absolutely important, super critical. They can be broader and longer in duration than employment agreements. It's not unusual to see 5-year non-competes, and for much broader geographical areas. I think the majority of deals I've been involved with have been retiring business owners. So very often these retiring business owners have absolutely no desire to go back in business. But it doesn't make those non-competes any less important, because it also seems that some of these retired folks just all of a sudden, like, they get 3 or 4 or 6 months into retirement and they're bored, right? These are entrepreneurs. They're used to it's not just the money for them. They're interested in doing stuff. They've got a skill they've done their whole life, and they just want to go out and start doing this again. So you need to have those agreements in place and make sure that that person is prevented from setting up shop, not just next door, but in a geographic region in which they could seriously compete with you. So super important. Makes sense.
I was just looking at the WB16 quick, and it was just a quick search, but I don't believe that there is much that addresses in the offer to purchase state form any non-compete. So that's certainly something that you'd think that would be included in that. Certainly, we'd like to define that as far as if we're going to fill out an offer to purchase or help a buyer fill out an offer to purchase, including, a non-compete. But it's definitely, very helpful to hear from you as far as what you look at and how you consider it.
I think that one of the things I think about is when I'm working with guys like Ben and his bank, is very often the bank and the buyer have parallel interests. The bank wants the buyer to succeed. And so as much as I hate to admit it, that maybe the bank thought about something that I forgot or is insisting on something that I don't think is important, very often the bank is going to have certain requirements of its own. And one of them often, correct me if I'm wrong, Ben, is to have this non-compete, right? So if you guys don't get it in the offer to purchase or the LOI or the purchase agreement, somebody very quickly at the bank is going to say, hey, wait a minute, this thing's missing a non-compete. It's that critical. And so somewhere along in the transaction, somebody's going to bring it up. I think the reason it doesn't show up as a check the box type item on a form is because it is a little bit squishy. You have to, you're looking at the geographical scope and the temporal scope and how to define it. And that does take a little bit of industry and sometimes legal, experience to address. But, that's why they have that extra space at the end of the form there. So you can at least, mention the non-compete, and it's critical.
That and the transition agreement,
Yep.
I don't believe is included in there. And certainly, it's not a check box that you check, but it's on the broker or whoever's working with the buyer on that end to be competent enough to include at least some sort of jargon and the additional provisions that then you can run with, right?
Yeah, like if I was going to give you or Matt some advice on this, right? You guys have been doing this long enough that you kind of know what belongs there. You're thinking about it, but you might have well, I'm not a lawyer. I'm not sure how I should actually define this. Some of the language that I use very often when I'm just coming into a deal and I don't really know much about the transaction or the parties or the industry, but I want to address it like in that LOI, is I'll say a transition agreement with terms acceptable to buyer and seller, or a non-compete on terms acceptable to buyer and seller, or buyer, right? So you're basically noting it out, you're calling it out, you're saying, hey, we're not doing this deal without one of these, and whether it's 3 years or 5 years or 80 miles or 100 miles, we'll figure that out later, or how much you're going to get paid or for how long later. But I want to put it up here right up at the top. This is super important. It's got to include it, and we got to iron those terms out before we get to closing. So that's I think a really good way to address it on those real estate forms: transition agreement, consulting agreement, non-compete, sometimes lease. If you're dealing with a lease, to add in buyer's going to a lease on terms acceptable to buyer. That way, because you don't actually know what type of lease what options are available yet, whether it's going to be an assigned lease that you're going to take over, or a brand new lease. You just know that it's super important, so it's got to be listed.
Yeah, leases are one of those funny little line items, because we as brokers, when we're taking an engagement agreement, if there's real estate, we're going to say, oh, you want to list the real estate? Yes or no? The answer is no. We're having to start off with that lease conversation. What happens when the buyer does buy the business, and they're going to rent this property from you? Are you okay being a landlord, or are you willing to do land contract, whatever that may be? But one of the pieces that I kind of wanted to bring up, Jan, is the right of first refusal. So in a lot of cases, we'll do a lease agreement that's a term, but it's got a right of first refusal or some option to purchase, right? So what is your, you and I have kind of gone back and forth because we've had a lot of diverse, contracts in the past, especially when it's tied to real estate. When it comes to an option to purchase, for a seller, that's a commissionable event for us brokers, right? So an easy default to that is to do a lease with a right of first refusal, right? So you want to kind of just define those options for the listeners out there?
Yeah, I mean, both those things get confused a lot. I think that people just jumble them up. And a right of first refusal simply means that if the landlord, the owner of the building, ever decides they want to sell the property, they have to give the current tenant the right of first refusal. And what that means is that if they get an offer, the terms are usually, if they get an offer from somebody else, a third party, they have to, within a certain number of days, take that offer and present it to the tenant. Say, hey, tenant, this guy who I don't know, he's not my cousin, he's an arm's length third party, just offered me $1.2 million for the building. Are you willing to buy it within the next 3 months for $1.2 million and $1? And so that's a right of first refusal, the right to buy it before somebody else does, at the price or just over the price that someone else is offering it. And it's just a way of that doesn't necessarily always work out for the tenant. Let's face it, tenant may not be in a position cash wise or borrowing wise to exercise that right of, to buy the building, but at least they've got an opportunity and in the future, if they're successful and they've got some money, they've got an opportunity to buy it before someone else buys it. An option is very different. An option is something that is negotiated ahead of time, and the buyer actually pays money for it or some consideration and says, look, I'm going to give you $10,000 for the right to buy this building in 5 years at $600,000. And it's something like that. It's a very well-defined, either an actual dollar amount or a formula in a certain period of time, and they have the right to do it. So it's not on someone else's terms. That deal is basically, and that's why it's commissionable, right? Is because the terms are agreed to ahead of time. The deal is all there. It's just the buyer has the option of either following through and closing on the transaction, or later on down the road saying, you know what, I don't want to be a landlord at this time. So I spent that $10,000 for the right to do it, but I'm not going to exercise my option to purchase. So those are both things that can work in a tenant's favor if they want to protect the option to buy the building or the right to buy it. I will say, as a separate matter, not connected to a deal, I generally, I think landlords tend not to want to do rights of first refusal, because if their building is on the market, the first thing that potential buyers are going to look at is the lease, and they're going to see that someone else has the right to pay $1 more than them. It can, not always, but it can scare away potential buyers. So you'll sometimes have trouble getting that from landlords. Now, options are a little bit different. I think they are bargained for ahead of time. The landlord's getting real money for that. They're getting paid money to buy that in the future. So that's usually something that can be negotiated. And again, having those in your lease all depends on how important it is for the buyer of the business to want to own the real estate in the future. I think we're all conditioned to think that owning real estate is great. And there's no denying that owning hard assets is helpful. It gives you collateral. It's solid long-term value. But sometimes you just want to be a business person, and owning a building, being a landlord, property management, the costs that go with it are pain in the butt. And so it's just as good to have a long-term lease where you can operate your business. You have a well-defined set of expenses, and for everything else, the maintenance, the roof, the parking lot, all that stuff, landlord takes care of it, and you've got a well-defined cost to that. So there's nothing wrong with just being a tenant.
Wonderful. Well, thanks for sharing, Jan. I mean, we've covered an awful lot of the points that go into an offer to purchase, an LOI, points that are inside the transition agreements and the documents, right? I want to switch gears a little bit, Jan, and talk to you a little bit more about the back office conversations, starting with, if it doesn't matter, I guess if you're working with the buyer or you're working with the seller, I guess it doesn't matter. But, we're always going to interject a third party counsel in here, and that's the bank's counsel. So, I mean, in a lot of cases, Ben, when you're working with one of the bank guys, the banks are working with the buy side and sell side lawyers. Those are conversations that brokers, banker, buyer, seller really aren't privy to, right? So I guess tell us a little bit about how those interactions go, because in my head, I can imagine what they sound like, but I want to hear it from you.
So I want to hit on the more positive relationships first. I think that the buyer and seller's counsel, this is an area where having capable attorneys who operate ethically, and who can establish a rapport with some trust, can add a lot of value to the transaction and benefit both parties. We tend to think of lawyers as being an adversarial system, like, you've got the defense and prosecution, and it's always this sort of arguing and fighting. And it is true that the buyer and seller's lawyers are representing separate interests, right? They're the seller's lawyer isn't there. He's not being paid for, and he's not ethically bound to worry about the buyer's issues. I'm there to, if I'm the buyer's side's counsel, to hash those issues out. But counsel, very often, if you get a good relationship going, you can get to the issues at hand very quickly. I think one of the benefits of having both parties get their lawyers early on in the transaction, you can jump on the phone, talk about the structure of the transaction, agree on the difficult parts and then the easy parts, right? And then you focus the efforts, and if there's negotiation to be done or a little bit of battling back and forth, at least you know what those issues are. Like, hey, these are going to be tough points. Let's try and give our clients some good advice about how to come to an agreement on this. The other stuff, let's just, agree on that now and deal with this. So I think it's the parties, the lawyers talking to each other, or you call it, back office conversations. It's true, they're probably going to be more by phone than anything else, but is solving some of the problems ahead of time before it even gets to the agreement. It's, in some ways it's risk assessment. In other ways, it's making sure their clients are covering the important points, but not spending too much time on stuff that's not important. Banks counsel is a little bit different. I had mentioned earlier that a bank tends to be have parallel interests with the buyer because they want that buyer to be successful. And that's all true. And I think that the bank's lawyers are performing a service that benefits the buyer very often. But the other thing that the bank's counsel is doing is sort of, as we lawyers do, is, we go to the end of the story right away and we say, okay, what happens if everything turns bad and everything's, a shooting war? Have we our documents? Have we done our job ahead of time? Do we have all these documents on file? Have we covered our butts in such a way? Is the bank going to make sure it has its security interests recorded properly? Have they opened themselves? Let me step back. Very often, at least in the deals that I'm working on, there are SBA guarantees. So the Small Business Administration comes in and guarantees the bank's loan. What that means is the bank makes the loan, but the SBA has an agreement with the bank that says, hey, bank, we're the government. We think it's a public policy good to lend money to small businesses that you might not otherwise lend to. So we're going to guarantee that if this loan goes bad, we'll pick up, say, 85%, 75, 80, 85, 90% of that loan, and you'll just be at risk for, say, 10 or 20% of that loan. But the SBA, as warm and fuzzy as that sounds, the SBA is also looking for reasons maybe not to guarantee that loan. And if the bank didn't do something right, then the SBA says, you know what, bank, you're on the hook for that whole loan. So the bank's counsel is also looking at a transaction that way, making sure that the bank has dotted its I's and crossed its T's in a way that it's going to be in compliance with the Small Business Administration. So, and sometimes I actually have access to the bank's counsel, and I'll frankly say that's a lot nicer because it's a lot easier for one lawyer to call up another lawyer and say, hey, this thing that you're asking for is kind of dumb. Here's some stuff that you might not know about the transaction. And the other lawyer goes, oh, okay, I get it. I can, let me make a note in the file and we'll address that. Or I'll understand the bank's position and we can kind of solve that lawyer to lawyer. But there's, I think at least half the time I'm never communicating with the bank's counsel, and that can be a little frustrating because you have someone that I am communicating with that says, look, I don't know why. It just says here on my list that I need it. So shut up and give it to me, Mr. Attorney. And that makes it difficult. It's always easier when the lawyers get to talk to each other because we think we're really important and that we can solve all the world's problems. So and frankly, everybody else would, like us to talk to each other too. So to your point, these back office conversations are, I think, generally help the parties involved because stuff just gets done much more efficiently.
Yeah, and what I'll say is the bank counsel is really there to represent the bank, and as Jan said, that a lot of times runs parallel to the buyer's interest, right? But the important part is they're there to the closing team and the bank counsel is there to protect the bank's guarantee.
Right.
Because if you don't have a guarantee, you have a much larger loss than if you don't. If you do have the guarantee. Now, with that said, on situations where there is like an eligibility question, right? Or there's something in the language where there's not an understanding, there is the ability to pick up the phone and get right on the horn with counsel to streamline the process, so we're not going back and forth. So if you start seeing a lot of ping ponging, that's the opportunity really to pick up the phone,
Right.
and say, let's get this ironed out and just get it done, so we're not wasting time. But like I think sometimes, like, there's a belief that there's a magic pen that can just cross off everything and to make an exception for everything,
Right.
which isn't the case. Like, there are certain things that fall under the line item as not something we can remove. And
Right.
So you have that. So, but in the areas where there's some flexibility, such as situations where something pops up, where maybe an escrow agreement can be used to deal with it, or there is a plan for how title transfers are going to happen, right? And that they're going to be the proper title transfers, right? So the bank can perfect their guarantee. Those are things that can be sent to the top of the house and then provide feedback back on an objection, right? To see how we can work around it. So the thing I always say is, on something, if there's a question, it never hurts to ask,
Right.
and to take it up to the top to figure out if there's a solution, or we have to, or if it is something where we don't have any wiggle room on.
Yeah, and I think the areas where it's helpful for the parties to sort of talk about it is when the definition of something is somewhat ambiguous, right? The goal is clear and the standard is clear, but what actually meets that standard or is a little bit gray. And so that's when sometimes, ultimately the lawyers to some extent are operating as risk managers, right? They're trying to properly quantify the risk. And again, if there's some ambiguity there, just getting on the phone and clarifying what's actually going on can help. And I'm not saying that you can talk around a legal requirement or compliance requirement, but there are just sometimes things just require a little bit of context. Not everything is black and white in the world, and so it's
well, yeah, I totally agree. One of the things that I think sometimes happens, right, is there are items that go on a list of adjustments that need to be made, right, that are ongoing changes, right? So like when and I don't know how every shop works, but you have items on a closing checklist, and you have counsel that's responding to those items that are within a credit memo, right? So out of a interest in saving time, those get rolled up and then inputted all at once, right? So until that happens, right, from a mechanical standpoint, right, those items remain on because the legal team and the closing team doesn't have it approved to remove it from the list, right? I think sometimes that gets lost out there. Like, yes, these are rolling change items that are going to occur, right? But we only want to send up the request once to have the back office do what they're going to do so we can take it all out at once, right? And those are like sometimes the easiest way to track to that, right, is just to make notes that this is discussed on this, right, on this item, right, of how it's going to be. Because that's where I see sometimes where like, I sent this in, I'm trying to get this should be off my list, right? Well, yes, you did send it in. We've noted it. It hasn't come off the list yet because there's a process that has to happen behind the scenes that you're not aware of, that has to take place, right? And that's like where the sauce is made.
bank voodoo.
Yeah.
Yeah, secret stuff.
Like you and I, Jan, have gotten on the phone before versus going back and forth on emails, right? And talked out things and been like, well, this is the way to fix this, right?
Right.
Where you're like, this has got to get off of this list. And I'm like, this is how I think it can be addressed.
Well, and to your credit, Ben, I usually only make that call when I've got a little bit of a head of steam built up and and you're always quick to answer the phone because you can tell that my head's about to explode.
Yeah.
And you say, Pierce, it's okay. Let's just, what's it going to take to make you happy? And then just talking to you makes me feel better, Ben. So even if I don't get the problem solved, I talk it through with you. But I think if I were to take another swing at this, when you talk about this closing checklist, it's like there could be SBA requirements, there can be bank, these are like Moses bringing down the stone tablets, right? These are the requirements, thou shalt not, and it's very clear, there's 10 of them, right? But when it makes it down and it drifts down to somebody who's putting the closing checklist together, there may be a number of people involved who have some or no limited or different amounts of experience, different amounts of education, and different interpretations, just as, because we're different people, like what they meant. So by the time it makes it onto the list, it actually says something a little bit different. And the times when I probably get a head of steam built as when it seems kind of like a bizarre, arbitrary requirement, and I think that that's the time where it really helps to jump on the phone and say, okay, what actually is the requirement we're trying to meet? And let's do that. Let's make sure we're meeting the bank's requirement, but let's get a better understanding of what seems like an arbitrary requirement is. And so it's just, these transactions are complicated. I think we can all agree that as you move towards the closing process, there's pages and pages of stuff that has to get done, and then it's a moving list, and the stress starts to build up as you approach that closing, because it's either going to be a wildly successful close or it's going to be a complete train wreck. And so everybody wants it to succeed. So,
well, and just when you think you've got it all figured out, they take the jar and they shake it up and down, and they say, these are the new rules. But I want to really talk about, because I think this goes to how working with different BDOs there, and in general of how deals move, right? So what I would say is, let's say you're working with a junior BDO, right? Maybe give them a little more deference in time and patience, right? Because they're learning, right? And we were all there at one time. I was there at one time, right? And they have to be given the ability, they may not know the answer. They may not have the years of experience of getting on the phone with the closing manager and talking through something, and then the closing manager, and they said, well, this is what we did last time, can we do this again? And use some of that soft power, right, that you build through being in your career, right? And the thing is we all at one time were at a stage in our career where we knew nothing, and someone had to water that seed and make it grow.
Still me.
And so I think sometimes when you're struggling, right, on something and you feel like you've hit a wall, kind of take into account the room and the audience of who you're working with, and okay, if it's someone that's a junior salesperson, right, but you've worked with another lender who's more senior, right, but this deal for whatever reasons with this junior lender, right, that's where you could use your knowledge set to say, hey, is there a way that we can facilitate a call with the closing manager or with counsel to see if there's a way to resolve this? Because right now the seller's counsel is really hammering me right now on something that could kill the deal, and I really could use some help on this to get this across the finish line, right? So
I think communication is so key across the board, from brokers, attorneys, CPAs, BDOs, lenders, closing team. I mean, and that's, I think, something that Matt and I try to foster and cultivate within our deals with our weekly diligence calls once we're under acceptance. And yeah, and
I know
just
how
keep
Jan
it going.
feels about our weekly diligence calls.
Yeah, and I know, Jan, it's a pleasure working with you. I know you're always open for that communication. Sometimes it's not the easiest, but we appreciate you coming on. We touched on so much as far as LOIs, offers to purchase, asset purchase agreement, stock purchase agreement, non-competes, transitions. I mean, the value that you provided today is amazing. Maybe we'll have you back on soon. It'd be great. Any final, recap items, Matt, Ben, Jan?
I just want to. Oh, go ahead, Ben.
I just wanted to say, because Jan, you came on this, we'd love to take you out for some tacos.
Yeah, well, I'm always up for tacos. So look, I'll second the communication piece. I try to hold myself high, to a pretty high standard and but I think but I also know there's times when, things get a little tense, but you're right, Ben, and I think things work better when you just realize we're all trying to get this stuff done. And, it's nice to have solid relationships with people who are all focused on the same goal. And, you can't have a decent relationship if you're not treating people with a little empathy and
respect.
So, yeah.
And Jan, I know Matt asked you earlier what your mantra or slogan is, and you can't really give yourself your own mantra or slogan, I feel like, right? It's kind of like giving yourself a nickname, but if I were to give you one, it would be the attorney of the people. So, and I've heard, I think I stole that from somebody else. I don't know who it was, but it definitely fits. But, we're happy that you could join.
Refer to me as the people's lawyer, and
the people's attorney, right?
And I've always, in my own mind, I've called myself a blue collar lawyer. So, if you get it, then I like that, blue collar lawyer. So, but
Matt,
I was going to say, on these due diligence calls, you kind of made light of that at the last minute. I just want to end and say that I think I told you a couple of weeks ago that you've sold me on these due diligence calls. I think initially I was a little skeptical of just jumping on the phone every week, but I have now learned that actually having the parties just every week or two just jump on a 10-minute call and say, hey, where are we at, is super important. That, as Ben can testify, sometimes the financing ends up taking, 3 months. And so the parties can start to wonder, is this thing going to come through? Or they change their mind, they get short. And I think having those calls every couple of weeks to just check in and make sure that everything's going fine, or if somebody has some questions or concerns, you address those. It's, it's super important. The deal's only good if you close it, right? If it falls apart for some reason, that's a failure. And so I'm sold on those calls now.
That's a blessing, right? Guys, so just kind of recap here. I mean, I think what we summarized today is that small teams win deals, right? Having open communication between all parties, third party people within the transaction, and being there, keeping the buyer and seller centric and top of mind, and their goals centric and top of mind, I think is really important. So Jan, thanks again for taking the time today. I want to put another plug out there for our sponsors, Strategic Wealth Partners. You can find them online at stratwealth.com. That's stratwealth.com. Again, Ruben, Joe, thanks so much for the sponsorship. Really excited for our August podcast. Ben, you and I have a mutual buyer that we worked with going on about a year ago. His name is Brian Cartwright. Brian bought a company called Reset, and it is an app that you can download, and it's all about resetting your diet. Brian was a searcher, and he is a successful searcher. Background in the technology world, and went out and said, I'm going to buy a company. And so he had a pretty diverse search study, Ben, I would think you would agree. But to all of our buyers out there, next month, Brian is coming on as our guest, and he's going to share his story. So with that said, Jan, thanks again for the time. You can find us on Spotify and YouTube. Please remember to like, follow, and share our content. And we look forward to talking with you guys next month. Thanks so much. Have a wonderful day.
The following content reflects the personal opinions and perspectives of the hosts. These views do not necessarily represent those of their employers,